If you're over 60 and own a gun, there's a good chance you still have rights nobody ever explained to you. And if you don't know them, you could give away freedom that the law never took away in the first place. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from a serious legal mistake. Hit that button now and make sure you don't miss updates that could protect your rights. Let me be clear. This video is not about politics. It's about something more personal. It's about you, your family, your safety, and the rights many older gun owners quietly stop using because they think age changed the rules. In many cases, it didn't. That's the part that shocked me. A lot of seniors don't lose their rights by law. They lose them by fear, bad advice, or plain confusion. So let's fix that right now. First thing, and this is huge, getting older does not automatically cancel your gun rights. There's no federal law that says once you hit 65, 70, or 80, you are too old to own a firearm. Most people think there must be some hidden age cutoff. There isn't. If you are a lawful gun owner, age by itself is not the reason you lose that right. Think about how often older adults get treated like they need permission for everything: driving, banking, medical choices, even what they can keep in their own home. So it's easy to start believing gun ownership works the same way. But here's the truth. In federal law, the big issue is not your age. The big issue is whether you fall into a prohibited category. That means things like certain felony convictions, some domestic violence convictions, unlawful drug use, or certain formal mental health rulings, not birthdays. Here's a hypothetical example to explain this. A 74-year-old widow still lives alone. She keeps a revolver in a bedside safe. Her nephew tells her, "Aunt Linda, you're probably too old to legally have that now." That sounds confident. It also sounds official. But it may be completely wrong. If she is not legally prohibited, her age alone does not erase her right. Now, this is where it gets interesting. Right number 2 is tied to retirement and benefits. A lot of seniors think that once they start drawing Social Security, or once they ask for help managing money, the government automatically flags them as unsafe with firearms. Most people think benefits and gun rights get linked overnight, but the truth is more narrow than that. Simply being retired does not make you prohibited. Simply receiving Social Security does not make you prohibited. Even getting help with finances does not automatically mean you lose your rights. That rumor spread fast for years, and a lot of older Americans still believe it. Here's what most people get wrong. A paperwork issue is not always a gun ban. A benefits issue is not always a gun ban. A family member helping with bills is not always a gun ban. But wait, there's something even more important. Right number 3 may be the one families misunderstand the most. Going to counseling, getting treatment for depression, seeing a memory doctor, or talking to a therapist does not automatically make you a prohibited person under federal law. Let me say that again, because this one matters. Treatment is not the same thing as disqualification. A lot of older gun owners are scared to get help because they think one doctor visit ends their rights forever. That fear stops people from talking honestly about grief, stress, sleep problems, or early memory concerns, and that fear can make everything worse. Under federal law, the line is usually much more specific. We are talking about formal action, like a lawful authority deciding someone cannot manage their affairs, or an involuntary commitment to a mental institution. That is very different from simply asking for help. Imagine you lost your spouse after 40 years, you can't sleep, you talk to a counselor, maybe your doctor puts you on medication. That alone does not mean your rights disappeared, but here's the warning. If a court or other lawful authority makes a formal finding, then the legal picture can change fast. That's why words matter. Diagnosed is not always the same as adjudicated. Treatment is not always the same as committed. Don't make the mistake of treating every medical issue like an automatic ban, because it isn't. And here's the bigger lesson from the first 3 rights. A lot of seniors give up guns or sign them away, not because the law forced them to, but because somebody at a kitchen table said, "I think that's illegal now. I need you to hear me on this." I think is not a legal standard. Fear is not a legal standard. Rumors from a cousin are not a legal standard. If you don't know this, here's what could happen. You could surrender property, change your living plan, or lose your peace of mind for no legal reason at all. If you're finding this helpful, imagine what you'll learn in my next video about the exact words to use when someone starts asking questions about your gun. Subscribe so you don't miss it, because the small things people say in stressful moments can change everything. Now let's move to right number 4, and this one matters if you travel. Many seniors spend more time on the road. You visit grandkids, you take long trips, you move between states for part of the year, and that is where people get trapped. Most people think once they cross a state line, every legal protection disappears. But there's a federal travel rule that many older gun owners forget exists. In simple terms, federal law gives you a narrow safe passage protection for interstate travel in certain situations. If you can lawfully possess the firearm where your trip starts and where it ends, and if the gun is unloaded and not readily reachable during transport, that federal rule may protect your travel through places with stricter laws. Let me break this down for you. Unloaded means unloaded. Not easy to grab means not sitting next to you on the seat. In many vehicles, that means locked away and out of reach. But here's the crazy part. This rule is not a magic shield for sloppy behavior. Don't make this mistake. Don't assume I'm traveling fixes everything while the gun is loaded in the glove box. It doesn't. Keep the trip clean. Keep the storage secure. Keep the firearm inaccessible. And always check the laws where you stop, because state rules can still get tricky around carry, lodging, and local handling. Right number 5 is one family's overlook until a funeral forces the issue. You have the right to plan how your guns pass to your heirs. And in many cases, the law gives specific ways to do that. That means your collection does not have to become a legal mess just because your family is grieving. Here's what just happened in thousands of homes across America. Dad passes away. The family opens a closet and finds hunting rifles, an old pistol, and maybe one item with extra federal rules, like a suppressor. Panic starts. One child says, "Just put everything in my truck." Another says, "No, touching it could be illegal." And suddenly nobody knows what is safe. The truth is, inheritance has rules, but it also has pathways. Ordinary firearms can often pass to lawful heirs, though state laws may control how. And if the estate includes NFA items, meaning special federally regulated items like suppressors or short-barreled rifles, there is still a legal process for lawful heirs. In some situations, that transfer can even be tax-exempt through the proper federal form. That is a big deal. It means planning matters, and panic helps nobody. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. That disclaimer matters most here. Estate law and gun law can collide fast. But the hidden right is this. You do not have to let confusion decide what happens to your property. You can make a will. You can leave instructions. You can create a trust if that fits your needs. You can name the right person. That is not just paperwork. That is how you protect your family from making a bad mistake during a terrible week. Right number 6 is more every day, but still powerful. In many places, you may lawfully gift or privately transfer a firearm to an adult family member under federal law if that person lives in your state, is old enough, and is not prohibited. But state law may add more steps, and that's the part people skip. Here's a hypothetical example. You're 68. Your knees are bad. You no longer want your old deer rifle. Your adult daughter hunts every season. You want her to have it. A lot of people assume that is automatically illegal now. Not necessarily. Federal law does allow some private in-state transfers. But this is where it gets interesting. Your state may require a dealer, a background check, a permit, or extra paperwork. So the right is real, but the details matter. That means the smart move is not to guess. The smart move is to verify. Because there's a big difference between I can never give this to my daughter and I can give it to her, but I need to do it the right way. Hidden in plain sight, that's still a right. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the people who want clear, plain English updates before the rumors reach them. Click subscribe and stay ahead of the confusion. Now, we get into the rights that almost nobody talks about because they involve privacy and police contact. Right number 7 is this. You do not lose all medical privacy just because guns are part of your life. A lot of seniors believe the moment they mention a firearm to a doctor, that information gets sent straight to the government. That is not how it normally works. Can doctors ask questions? Yes, sometimes they do. Can certain records matter in limited legal situations? Yes. But most treating providers are not simply reporting ordinary gun ownership into a background check system because you showed up for a checkup. That is one of the biggest myths out there. Here's what most people get wrong. Asking about fall risk, depression, or home safety is not the same as launching a gun rights case against you. Now, don't twist that into something reckless. If someone makes a real threat, or if the law requires a report in a specific emergency, the rules can change. If there is a court order, a danger issue, or a serious and imminent threat, privacy rules may allow limited disclosures. But that is very different from saying, Grandpa told his doctor he owns a shotgun, so now he's on a federal list. Most of the time, life is not that simple, and the law is not that broad. Right number 8 is one you need to remember during stressful moments. You still have constitutional rights when police knock on your door. Even if the visit starts as a welfare check, you still have rights during a traffic stop. You still have the right to stay calm, to ask questions, and in many situations, to refuse consent to a search. Imagine this. A neighbor has not seen you in 2 days. Police show up to check on you. That can happen, especially for seniors who live alone. Now imagine an officer says, "Mind if we look around?" A lot of people panic and think saying no makes them guilty. Not true. If the officer has a warrant, that is one thing. If there is an emergency, that may be another. But a polite refusal to a voluntary search is still a right. Same with a traffic stop. If your state requires you to disclose carry status, follow your state law. If it does not, do not start rambling. Keep your hands visible. Stay respectful. Do not reach for anything. Ask how the officer wants to proceed. And remember, you do not have to talk your way into trouble. Silence, or asking for a lawyer, is still a right. This is the part that shocked me when I first saw how often seniors forget it. People who have lived clean lives for decades suddenly act like every badge erases every boundary. It doesn't. Respect the law, yes. Obey lawful commands, yes. But do not volunteer rights away because the moment feels intimidating. And right number 9 may be the most hopeful one on this list. If gun rights were lost because of certain old mental health findings or other legal issues, there may be a path to restoration in some cases. Not always, not everywhere. But sometimes the story is not over. Most people think once rights are gone, they are gone forever. Sometimes that is true, but not always. In some states and under some legal programs, a person may be able to seek relief, set aside an old finding, or use a restoration process that the law allows. This is especially important for older veterans, older adults with very old records, or families dealing with outdated assumptions. Let me explain why this matters. If a man lost rights decades ago after a mental health commitment during a crisis, his family may assume there's nothing to do. They may never ask. They may never check. But in some cases, the law gives a doorway back if the person qualifies. That does not mean the answer will be yes. It means the answer is not always no. And that is the whole theme of this video. Seniors are told no so often that many stop checking whether the law actually says no. That is dangerous, because hidden rights stay hidden only when nobody asks the next question. Laws change fast and confusion spreads even faster. Subscribe now so you're not caught off guard by the next rule change, the next rumor, or the next bad piece of advice from someone who sounds confident but has no clue what they're talking about. So here's the takeaway. If you are a senior gun owner, your age alone does not erase your rights. Retirement does not erase them. Treatment does not automatically erase them. And in many situations, you still have strong rights involving travel, inheritance, privacy, police contact, and even possible restoration. Pause. But here's the warning. Hidden rights only help you if you know them and if you follow the details correctly. So subscribe right now, share this with a parent or grandparent, and help one more gun owner avoid a mistake that never should have happened. And one final reminder, in simple terms. This video is for education. Laws can vary by state, and your facts matter. Before you act, talk to a qualified attorney in your area.